Good morning. The District Court of Appeal of the State of Florida in and for the Second District is now in session. The Honorable Craig C. Valenti, Judge presiding. Those having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court.
Hey, good morning. Welcome to this session of the remote oral argument for the Second District Court of Appeals. I'm sure you all know each side has an equal amount of time, but the appellant can divide it between an opening and a brief rebuttal not to exceed 5 minutes. The first case can queue it up. After they're done, they'll exit the virtual courtroom, and the next case will queue up. The first case can be Fuller versus State of Florida. When they're ready, let me know. There's one.
Can you hear me?
Yeah, we hear you fine. We see you also.
Wonderful.
But everybody's ready to go. Who's the appellant? Mr. Isaac?
Good morning. Good morning, Your Honor. Mike Isaac on behalf of Mr. Fuller, who's the appellant in this case. If I could get a 5-minute notice so that I can reserve that for rebuttal, please.
I'll do my best.
Okay. Thank you, Judge. Well, I'll write down the time on my sheet. Good morning, Your Honors. In this particular case this morning, we're dealing with a very narrow issue. It's a case of first impression in that no other DCA or the Supreme Court has addressed the parameters of Florida statute 316.1932 subsection 1, section F2B in the context of the factual scenario that's presented in this case. Unless somebody on the panel wants me to go through an extensive overview of the facts.
I wouldn't recommend that. I mean, your issue is more of a legal issue, right?
I agree. I think that I wasn't planning on going through a large or extensive.
We'll ask questions if we have them. If not, just proceed. It's your time.
So this case presents a very unique factual scenario in that my client was apparently involved in one car accident. There's no evidence anywhere in the case of alcohol being a factor other than medical blood results. And what ends up happening, the trooper comes to the hospital to conduct a civil traffic or to complete a civil traffic accident investigation and is made aware of sensitive, constitutionally protected medical blood results. And then instead
who made him aware of that? Are you able to tell us? Was it a nurse?
We don't know. It just says hospital staff.
Okay.
They don't have the witness. They don't know who it is.
Okay.
So somebody on the hospital staff discloses the numerical value, and rather than taking that information and asking for a legal blood draw, which is what the statute authorizes the disclosure for, the trooper just leaves the hospital and then takes that sensitive information, discloses it to the state, which then prompts the state into using that information to continue investigating. Ultimately,
so when you say use, in your conception of the facts and the procedural facts, how do they use it? The state attorney's office used it to do what? To seek a subpoena?
So correct. The trooper disclosed, and at the time of pre-filing and pre-disclosure of the evidence, I don't know what the state attorney knows. I only find out after I get discovery that the numerical value was disclosed pre-filing, pre-everything to the state, and then the state took that information once they had it, and as part of pre-filing,
and they didn't use that for
medical records.
They didn't use that in their application for in their request for the subpoena, though, right? They didn't cite it. They didn't alert the court to their knowledge of the actual information conveyed by the healthcare provider.
No, they did not. But the problem is that
so being tipped off, so the cops tipping off the prosecutors regarding information that the cop, for lack of a better term, law enforcement officer was legally permitted to be apprised of by the healthcare provider pursuant to the statute is a use. So, and who is using it? So in other words, your argument talks about the use put to the information, the information being put to use by the law enforcement officer. So you're saying the law enforcement officer used it to alert the other arm of the state, the prosecuting authority.
Correct, because conceptually, if we think perhaps in hypothetical terms, if the law enforcement, instead of disclosing the numerical value, which I submit the statute doesn't allow them to do,
is the law enforcement officer permitted to call someone in the state attorney's office and say, pursuant to this statute, a healthcare provider alerted me that X driver was over the limit? Just say over the limit.
No, because
so that's also.
again,
so can I? So I figured that would be your answer. So let me ask you this. So I just want to be clear. I understand your argument. So if the law enforcement officer had requested a blood sample, he would then be permitted to share with the results of that draw with the state attorney's office. But because the law enforcement officer did not request a blood sample, the state attorney's office cannot be apprised of the results of the blood draw performed by healthcare providers of which they informed the officer. Is that right?
I agree with that, actually. Yes, because if you think about,
I'm just asking if that's your argument. Okay.
Yeah, absolutely. If the law enforcement officer, because he knows the numerical value, complies with the statute, gets a legal blood draw, sends it to the crime lab, and they get the results, there's no infirmity here.
Well, before you get too far into your argument, can I interrupt you for a jurisdictional question?
Absolutely, Judge.
You're appealing the denial of the motion to suppress. You stated the grounds upon which the appeal is based, but there's no stipulation that if you win the appeal, that it would be dispositive. How do you get around that? How do we have jurisdiction over this case?
Well, thank you for asking that question.
Welcome.
I addressed that in my brief, but I'll reiterate the point. There are two things. There are two tests, and I don't remember the name of the case I cite, but there are two requirements that I have to meet. One, we have to specifically preserve, which we did both in written form and verbally. Second of all, the analysis has to be, without the evidence, could the state go forward? And since there's no evidence of alcohol in this case, and under either theory of prosecution, the state has to have evidence of alcohol, they would never get past the judgment of acquittal. I didn't need, in this particular case, in all candor, I didn't need an agreement or a stipulation because this is the only evidence of alcohol. Without this, and that's what's so unique about this record. There's no evidence whatsoever of alcohol being a factor. So without that, the state will never meet the elements in a judgment of acquittal.
This dovetails into the other argument, but can the state, is there any case, and of course, counsel for the state will let us know, but her perception, but of the answer to this question, is there any case in which the state can make its case without specifying to the jury what it believes the substance to be that impaired the driver?
No, I don't believe it can, because either if you're talking about alcohol, you need evidence of alcohol. If you're talking about evidence of chemical controlled substances, you would need some evidence of chemical controlled substances. And
so in other words, you would agree that if there was some evidence of a specific substance, that you don't need a scientifically conducted medical procedure to adduce blood alcohol level, right? The state can prove its case based merely on the indicia of impairment, right?
They can, but ordinarily with impairment, you have independent evidence of alcohol, whether it's an odor of alcohol, admissions to drinking, the bar ban.
Glassy eyes, slurring words.
I'm sorry?
Glassy eyes and slurring words. Which is in the record, right?
It is, but what caused the glassy eyes.
Well, yeah.
Okay, so again, and the trooper conceded that having been involved in a car accident and my client's in a neck brace and he's on a bed, he's on a stretcher, everything he observed could have been attributable to being involved in the car accident.
Mr.
So I'm
Isaac,
sure
can-
that-
Mr. Isaac, can I return you to the statutory argument?
Sure.
Because I want to pin a point down that's troubling me a little bit about it. It seems like your argument is that I'm just going to say 1FB for short because it's a lot to keep the numbers in order. Your argument is that 1FB binds the state and creates an infirmity to the state to utilize this information in how it goes about however it gets the information from a healthcare provider and what it does with it. Is that a correct summation?
I'm sorry, I didn't follow.
It might be so basic, but it seems to me your argument is 1FB applies to the state. It binds and prohibits the state from using information that is disclosed by a healthcare provider when they receive evidence that there's intoxicant in the blood. Is that correct?
No, I think 1FB narrowly applies to law enforcement and only law enforcement and establishes parameters of what they can do.
Fine. Law enforcement, the state, I'm using those terms interchangeably.
Okay.
So am I accurate?
Yes, the statute limits
Okay.
the parameters of what law enforcement can do.
Here's my problem with that. Right?
Okay.
And hear me out for this question and help get me past this if you can. The particular section that you are relying upon, any such notice shall be used only for the purpose of providing, is written in the passive voice. All right. Obviously, a test can't apply itself. It has to be done by an entity or a person, right? Any such notice is the subject of the sentence, shall be used only for the purpose of providing the law enforcement officer with reasonable cause to request the withdrawal of a blood sample pursuant to the section. What is this read in context with? Well, when you read earlier and afterwards, it's read in context with provisions that provide protections to healthcare providers, right? Basically, there's a constitutional prohibition against disclosing private personal information obtained by healthcare providers in the course of treatment. So B opens with, notwithstanding any provision of law pertaining to confidentiality of the hospitality records, if a healthcare provider, that's the subject and focus of this provision, who is providing medical care in a facility becomes aware as a result of any blood test performed in the course of that medical treatment, that person's blood alcohol level meets a certain level. The healthcare provider, reiterating the subject, may notify any law enforcement or law enforcement agency. There's nothing in there that says, there's nothing in there that binds the law enforcement. It just says in the passive voice and in connection with the prior sentences, hey, the reason that you healthcare provider are allowed to do this is to allow law enforcement to seek a blood draw. If you go on further in the statute, it then talks about what the notice is supposed to contain. It says the healthcare provider is not considered to have breached any duty by doing this. In fact, they get civil, criminal, and this is under subsection E. They get civil, criminal, and administrative immunity when they comply with this. But the whole setup of the statute is speaking to healthcare providers. You're trying to turn this entire section here and subsections that are both before and after it into something that says, law enforcement officers, you shall not use this for any other purpose. So help me with that. Help get me past the overall context of the statute that applies to healthcare providers.
Well, I'm unaware of any rule of construction that precludes a nuanced sentence within the statute to apply in a very narrow way, so long as the nuanced nuanced portion of the statute, when read in paramateria with the remainder of the statute, gives meaning to the rest of the statute. And by carving out this one sentence, by focusing on this one sentence, it's not invalidating the interpretation of any of the statute before it or after it. It's not did we lose
Yeah,
Judge
it looks like we
Atkinson?
did.
Oh, I'm sorry.
There it is.
He can
Okay.
hear us. He just moved.
Oh, I'm sorry. We're not changing or altering the meaning of the statute before or after. And I hear what you're saying, that it's in the passive, but if we look at the mandatory permissive,
I guess what I'm suggesting is that, gosh, the legislature could have been so much clearer on this if they had just put in there, law enforcement officers or the state shall not use these disclosures for any other reason. Instead, they use this kind of mealy mouth. It's a flow. I mean, it's the end of a paragraph that's talking about how healthcare providers can do what they feel compelled to do, which is disclosing this information to law enforcement officers without opening themselves up to all sorts of civil, criminal, and administrative liability.
that concept, however, Judge, is covered by the omitted canon, the omitted case canon, which says a matter not covered is treated as not covered. So in addressing that, there's a
5-minute warning.
right on point.
You asked for a 5-minute warning. You now have it.
Can I add to that question, Judge Lucas's question really quick?
Sure.
You're not only saying that that the only for the purpose of providing phrase applies not to the healthcare provider, but rather to the state. But you're saying it only applies to a subset or one individual actor, and
That's
that is
it.
the law enforcement officer. It doesn't even apply to the state attorney's office.
Well, they wouldn't be part of it. It just says, and I think that the sentence carves out a very limited use.
In other words, the law enforcement officer himself, it's only him or her. It's not the healthcare provider. It's not the state attorney. That phrase only applies to the law enforcement who obtains this information.
Correct. And with that,
Mr. Ezek, you're at 4 minutes. If you want me to save 4 minutes, I will for your rebuttal.
Yes,
Okay,
I'll say
got
4
it.
minutes. Thank you.
Ms. Buffington, you're next.
May it please the court, counsel. Good morning, your honors. This court can affirm the judgment and sentence in this case in two ways: on the merits or through the lack of there being a stipulation or finding of dispositiveness below. Looking to the merits, first off, we didn't talk about, but in 2A, right above 2B, there is the language regarding, however, the failure of a law enforcement officer to request the withdrawal of blood does not affect the admissibility of a test of blood withdrawn for medical purposes. So in our case, there was no request to have the legal blood withdrawn, and on its face, the statute is allowing, it says that does not affect the emission through a medical blood test when it is obtained, in this case, through a proper subpoena. Under the defense theory, which was that once this information was disclosed, it could be used for one purpose and one purpose only, and that was to obtain the legal medical blood draw. So if we go forward and presume that Mr. Fuller was asked to provide the medical blood draw based on this information that law enforcement was legally entitled to have, and he agreed, okay, fine, we have it. If he refused, we are in the situation that we're in right now, and that he writes up his report, sends it to the state. Under Mr. Fuller's theory that the law enforcement officer was supposed to exclude this relevant information in his report from his investigation, that is not how law enforcement is trained, and that's not how we want them to behave. We don't want to promote any policy that would force law enforcement to make these kind of judgments about what to exclude from their report. That's the job of lawyers and the court. So on the merits, we believe
Well, that's a good practical reason to believe that you're correct. Could I ask another textual reason, which I didn't have the time to ask Mr. Isaac? What about subsection 3, notwithstanding any provision of law pertaining to the confidentiality of the hospital records? information relating to alcohol content of the blood obtained pursuant to this section shall be released to a court, prosecuting attorney, defense attorney, or law enforcement upon request.
Shall be released. Yeah, there it is. I do have it highlighted, even though I didn't mention it. Yes.
I mean,
it's-
I may be I mean, I'll make, I'm assuming that the information relating to alcohol content obtained pursuant to this section would be the, not just, would be the information obtained by the law enforcement officer, even before a blood draw that he or she requested. Maybe I'm
Yeah.
missing something, but
No, it's consistent with it should be released. Notwithstanding confidentiality of the records. It shall be released to a court, prosecuting attorney, defense attorney, law enforcement in connection with alleged violation of 316-193 upon request. So,
I mean, I'm sure the argument can be made. I think it would be a difficult one to make, to say that that information is only the information regarding blood alcohol content obtained pursuant to a blood draw requested by the law enforcement officer. It's rather broad. It says information relating to blood alcohol content of the alcohol content of the blood obtained pursuant to this section. So I'm presuming that would mean not only a blood draw requested by the law enforcement officer, but also the blood draw administered by the hospital staff, which gave rise to their permission to notify the law enforcement officer. In other words, the blood alcohol content obtained during the normal course of medical services provisions that gave rise to the notice to the officer
right,
would be covered by subsection 3,
it
unless
looks
there's
like,
another reading.
yeah, it does look like that. So. There is no real reason to have suppressed these medical
Just-
records, which were obtained by subpoena after notice and hearing.
Can I ask you one question to make sure? The hospital had a blood draw done in the routine procedure of a person being admitted pursuant to an automobile accident. That was SOP for the hospital. Is that true or false?
You know, I don't know the hospital's standard
We don't,
operation.
okay, it's not to reconcile. This blood shows up, it's his blood. There's no dispute, it's his blood. And it was not done at the request of law enforcement, but the argument is, so what? It could have been released regardless. Is that true?
It
It
could
could
have
have been
been,
released to the state because they had the blood draw and it was in the record. It was from that night.
they had to obtain a subpoena, you know, they couldn't do it as was done in Kudik, where the law enforcement officer just went in and took the medical records without a subpoena. That was incorrect, and they said there, what should have been done was what was done here, that the law enforcement officer should have gone to the state to get a subpoena.
Okay. I wasn't sure. I thought Judge Atkinson was going towards, they get it regardless of the subpoena, but if they had a subpoena, that's like belt and suspenders.
Yes, I did not look at or think about it for the briefing, subsection 3. I mean, I do have it here in front of me, and I have highlighted the language that Judge Atkinson just referred us to. And that seems to be that upon request, it should come in, but maybe I am missing something. This talking about the confidentiality. It shall be released to a court, prosecuting attorney, or a law enforcement officer in connection with alleged violation. We do have the specific section, though, about getting a subpoena for protected medical records, and that was the compromise between law enforcement being entitled to evidence of crimes and also protected personal medical records. And so we have the statute which says you only can get it after notice and hearing with an opportunity to object. And
Is there, I don't know that I know, I follow your point there, but what does subsection 3 mean then? Could it mean just, that could indicate that it actually just means the information that we're talking about in the subsection at issue. In other words, Officer so-and-so obtained information relating the alcohol content of the blood. It's 0.09. upon request, information shall be released. Is that something that could be distinguished from subpoenaing the medical records? I don't know, but I mean, you can't ignore that statute.
I don't know, it is much broader. I would think, I would have to say that I just plain don't know, but I wouldn't think it's usurping the requirements for, because we do have the case, Johnson, I think, saying that the state's investigative subpoenas could not usurp the protected medical records, and you had to go through the specific subpoena with notice and hearing as that compromise. Unfortunately, I don't think we have to get to this section.
And there could be questions down the road, if I'm correct, or that this is relevant to the question, which is, being provided to those entities or individuals doesn't mean that it's admissible. It doesn't mean you can subpoena the records that have been in court. It just means that information shall be released to the court, prosecuting attorney, defense attorney, law enforcement officer upon request. Can I ask you another question? Can the state make, that's a question I asked Mr. Isaac, can the state make its case without indicating to the jury or adducing evidence that would support a conclusion in the mind of the jury about which specific type of substance impaired the driver? Can the state make its case? Is there any case law cited by you or by the defendant in this case that says either way? In other words, judgment of acquittal because state of Florida adduced evidence that is indicia of impairment, but you did not adduce any evidence indicating what specific substance caused the impairment. Is there any case like that, or is there any case the other way, which the court said, hey, you know what? They could just say he was obviously impaired. They don't have to adduce evidence about a specific substance.
I believe, what he's been charged with, we would have to introduce what he was impaired with. I believe it is fair inference on slurred speech and et cetera, the glassy eyes, you could say, and perhaps even have some expert coming in that these are classic symptoms of what I see with impairment with alcohol. Because we didn't have a stipulation of the facts below, we don't know what other evidence there may be. Now,
but from what we could see, okay, we don't know. But of the evidence we do know, other than, if Mr. Isaac is correct that well, that doesn't even matter whether he's correct for the separate conceptual argument regarding dispositiveness, right? Just presuming, because that's what you kind of do. You presume he's correct that this evidence should be suppressed, whether we agree with his argument or not. And then the determination is, would the state have been able to go to trial without the evidence? I'm presuming he's going to say the evidence to be suppressed is everything. Is there any way to get to the evidence of alcohol intake?
I believe that the state doesn't have to have a case strong enough that the jury's going to find beyond a reasonable doubt that this was impairment from alcohol. And I believe that was the Vaughn case. It's just, can the state go forward? I think we can make it.
But what do you have though? What do you have? Okay, so we're not saying you could have admitted the hearsay testimony of the officer that he heard from the healthcare provider that Mr. Fuller was over the limit, unless you're going to say you could admit that. And then, but he's saying that should be suppressed as well, obviously. And then what would you have? What could you go to trial with that would be evidence of some indicia of alcohol intake?
Well, what we have is impairment with specific characterizations of impairment.
Well, you just conceded that you couldn't go to trial without some evidence indicating what substance had caused the impairment.
I'm indicating,
or did you not? Maybe you didn't.
We would have had to prove, which of course we don't now because we have a plea, but we would have had to prove that it was by impairment. Now, perhaps we have other evidence that we could bring in, experts regarding, these, and then an inference based on the symptoms of impairment about what it could be. We also don't know, perhaps the emergency people who had him in the back of the ambulance taking him to the hospital. Maybe they smelled some alcohol. We don't know, and that is because we didn't get stipulation or a finding of what the.
Well, let me, Ms. Buffington, let me push back a little bit on the finding. You do have in the judgment and sentence, it says reserving his right to appeal the dispositive motion. Like if I just read that cold, how do I not read that as the court saying, yep, it's dispositive?
Does it, in the judgment and sentence,
I
where
believe so.
it says
Or-
per attorney. So in front of that, it's per attorney reserving the right to
Yeah.
appeal. So I interpret that as being, that's been recited and the clerk has put down the judgment and sentence, not a finding.
Kind of a weird thing to include though, because usually we don't gratuitously insert attorney representations into judgments unless they bear on a finding or something of legal significance. You see what I'm struggling with? Like what, if the court was saying, now I'm not making a finding of dispositiveness, why put that in there? Like why is that, I guess, why is that in there?
Because the parties were agreeing that he was reserving a right to appeal, but then the several cases cited in the state's brief are,
Which can't happen unless there's an agreement as to dispositiveness.
which is why the many cases are, summarily affirmed. Previously, they used to be dismissed, but they're summarily affirmed. And without the finding, without the stipulation, because the state is the one that's giving up the right to prosecute, perhaps they were choosing not to prosecute even in light of evidence. That is a decision that they get to make. And the Churchill case says, that we are stuck with that even when the reviewing court can see plainly it was not dispositive.
It's just it is admittedly a weird, and to go to your argument, it's a weird way for a court to announce a finding of dispositiveness. To bracket it with per an attorney's representation. Or the attorney represents that it's dispositive. It doesn't, I don't know what it does. It's kind of a weird thing to have included, I think.
There was no mention at the plea hearing, not a peep, which I did send in the Lamb case out of this court of supplemental authority because I think it went further. It made, an inferred finding of dispositiveness, but we don't have anything like that here. We don't have the court saying you have 30 days to appeal. We have the state just silent in the face of the agreement. And the cases out there say that that is insufficient. Even the state signing on to a plea agreement, which they did not sign on to this plea agreement. There's the plea form by Mr. Fuller without the state. So we believe on either ground that this case should be affirmed.
Can I ask you one more question? Was there a pretrial motion to dismiss filed by Mr. Fuller that was ruled on by the court?
I'm unaware of that. I'm sure Mr. Isaac would know, if that was it. It's not in our record.
Well, I mean, the only reason I'm asking that the argument he's making, if it's a legal argument only, that would be raised in a motion to dismiss. If that was denied, it would be required to be appealed with the whole case at the end of a conviction by a jury or a no contest with a stipulation. So I'm confused on the procedural history. Maybe it's because there's a new judge on the bench. I don't know. I didn't recognize the name.
I know that the state below was arguing that this motion to suppress was a duplicate effort from the hearing, the Hunter hearing.
Subpoena.
I'm sorry?
To challenge the subpoena.
Yes, exactly. So whether there had been anything separate from that.
Well, you don't need to opine. I just thought maybe there was a yes or no answer. You can move on. I don't want to take up your time with my stupid question.
And I was happy to see that you were on this panel, Judge Valenti, since you wrote that concurring opinion cited in the brief before I knew that you would be here regarding dispositive.
Pure serendipity.
Yeah, wasn't it?
Counsel, it says per attorney preserving right to appeal. I mean, that could be read to mean per the attorney's preservation of the right to appeal the ruling. It doesn't mean that necessarily. I don't necessarily read it and mean that it's dispositive per the attorney.
I agree with you. Yeah.
Per attorney preserving right to appeal ruling on dispositive motion. I mean, I'm not saying it's not confusing. I'm just saying there's more than one way to read it, and one of the even if one of the ways to read it is that the court is only saying it's dispositive only per the attorney. Yeah.
Sure. I do agree with that, Your Honor. We can look at the plea itself, and we do have defense counsel, mentioning its reserving the right to appeal dispositive motion but we just don't have anything beyond that, but anything by the state, anything by the court indicating it was making a finding, nothing saying you have 30 days to appeal, just taking the plea. So for that reason, and because a finding of dispositiveness needs to be, a stipulation by the state needs to be clear. And we just don't have that here. And absent a finding, unless we were going to look at that statement per attorney that the court is finding it was dispositive.
I don't think,
I have another-
your opponent makes that argument. I didn't
Pardon
hear
me?
him make that. I don't think your opponent made that argument, that you're answering an argument that wasn't raised. He said it was dispositive because it was a legal issue only, not because it was dispositive by the judge's finding. I'll let him answer that if he has a different answer.
I believe he was always maintaining it was dispositive because that's the only reason he's going to have an appeal. If it's not, he's just having a plea and then they're going home.
I didn't phrase the question, but I'll withdraw the question.
If there are no further questions, the state would rely on it.
Well, I have a question. So, again,
course.
that's real. Well, if you have more time, is there more than?
Oh, you got a minute left.
I'll take it.
Fire away.
And this you could answer honestly one way or the other, and so could Mr. Isaac. You know, I understand. I've read the case law that you know indicates that there is a privacy protection in the medical records. But it's what's curious to me is that if you separately in isolation look at the history of Fourth Amendment case law, it usually or often indicates as a sine qua non an expectation of privacy. And how can you have an expectation of privacy if you as a driver on the roads are a person who accepts the privileges extended by the laws of the state operating a motor vehicle within the state, and then you've deemed to give your consent to have your blood drawn? How can you have an expectation of privacy in that particular aspect of your medical records? Only to the extent that they indicate your blood alcohol content, which you have given up. The privacy right, the expectation of privacy of which you've given up by driving on fuller roads. I'm just curious.
I think because I agree with that, and that you've also given up your right to withdraw that consent, even if you are unconscious or in a state where you cannot give your consent. The statute says you are deemed to have not withdrawn it. What I think is like the medical records as a whole are protected, and that's why there's the right for hearing and a notice to excise what is relevant to the investigation, specifically the blood alcohol content, or any other.
If I interrupted you to say your time has expired, I'm going to give the other side an extra 30 seconds. Okay, your time is over.
I'm
Mr.
done.
Isaac,
Thank you.
Thank you, Judge.
I'm going to give you an extra 30 seconds. 4:30.
Thank you. I want to start off by addressing the question that Judge Atkinson gave. If you look at section number 3, the reference is in the middle of the sentence, substances in the blood obtained pursuant to this section. The statute is talking about legal blood draws. So it's permitting the dissemination of the legal blood results. This section 316.1932 is not about blood draws, medical blood draws.
But isn't it about information relating to the alcohol content of the blood? And isn't that information obtained by a law enforcement officer from a medical health provider pursuant to this section?
No.
Information relating to the content of the blood. Just been talking this whole argument, about information being conveyed, notice of the blood alcohol content provided by that. Isn't notice of the blood alcohol content conveyed to a law enforcement officer under 2B? Wouldn't that fit within the broad language of information relating to the blood alcohol content obtained pursuant to this section?
No, I think your conflation is law enforcement is allowed to know the medical blood so that they can request a blood pursuant to this section. So when you see that language,
that's just begging the question. You're begging the question.
I'm sorry?
You're begging the question.
Well,
I asked you why that why the term information relating to the alcohol content of the blood obtained pursuant to this section only pertains to a blood draw requested by the officer. And you said the answer was because it only pertains to the information obtained pursuant to a blood draw requested by the officer. That's begging the question.
This section applies to legal blood draws. And we're looking at a very narrow exception that allows dissemination of medical blood to obtain a basis for requesting a legal blood draw. So when you see the language blood pursuant to this section, it's only referencing legal blood. So it's saying even though there might be protection out there that deals with other blood samples, they can still disseminate legal blood draw to the prosecuting attorney and to the defense and to the court. And so that's how you have to read this section in conjunction with the entire section. And
So of what under the other F2B, of what may a healthcare provider notify a law enforcement officer?
they can tell them the
Of
numeric
what?
value for the limited purpose of
Right.
obtaining
So
a
of
legal blood
what
draw. Nothing more.
may a healthcare provider notify a law enforcement officer under F2B?
I'm sorry, repeat that.
Of what may a healthcare provider notify a law enforcement officer?
The numerical
Under-
value.
Yeah, the result of a blood test. Isn't that information relating to the alcohol content of the blood obtained pursuant to this subsection?
No.
This section.
No.
Why? Why not?
Because that language are talking about a legal blood draw.
What language?
The language in section 3 is
Oh.
is talking about a legal blood draw. You can
Why?
disclose a legal blood draw.
Why?
Mr. Ezick, just to be fair, you've got about 40 seconds left. If you want to finish the answer or say anything new, it's up to you.
Well, I don't want to take up any more time with. I'm sorry, Judge Atkinson. I
That's all right. It's I brought it up and it was
the motion,
go ahead.
Judge Lucas. The motion that I raised is not duplicate because at the time of the Hunter hearing, it's pre-filing, and as I indicated, I'm moving in the dark. I can't be held accountable for evidence that I don't know about, I don't have. So once charges are filed, discovery is made. Now I know, that there's no evidence of alcohol. Now I know that the trooper didn't ask for blood. Now I know that my
You've
client
just surpassed your time, Mr. Ezek.
Okay.
Thank you very much.
All right. Thank you, Your Honor.
Conclude this case and we'll move on to the next case. That's the insurance case. Lewis Brown and Safe Point Insurance.
Good morning, Your Honor.
Good morning. How's everybody? You ready to roll?
Yes, Your Honor.
All right. You're Mr. Bernard, right? You go first.
Correct. Okay. Good morning, everyone. My name is Eric Barnard, and I represent the appellants in this case, Lewis Brown and Murder Moreno. And this is an appeal that, I'd like to reserve 5 minutes for rebuttal, if that's all right.
You got it.
All right. Thank you. This appeal challenges the trial court's dismissal of the appellant's lawsuit for failing to refile its lawsuit within the 5-year statute of limitations prescribed in Florida Statute 95.11 instead of the tolled statute of limitations outlined by Florida Statute 627.70152 subsection 3. Alternatively, this appeal challenges the trial court's refusal to equitably toll the statute of limitations, which would allow the insurers to proceed on their case based on the merits of this claim. So what we're dealing with is a Hurricane Irma case. This was a case that had initially been filed. They litigated this case for about 3 years. We had to voluntarily dismiss this case because the clients were out of the country, could not attend trial. SafePoint moved for entitlement to attorney's fees and costs, which was granted. And within that order, there were some factual findings made by the court, which essentially would have prevented us from filing this lawsuit again. So we had to clarify those things. We moved for rehearing, got some clarification from the court on March 7th, 2022. At that point, it was announced that the previous attorney for SafePoint, Kurt Allen, was no longer going to be representing SafePoint. We waited for new counsel to go ahead and be retained on behalf of SafePoint. We began negotiating settlement with that new counsel that was retained sometime in July 28th, 2022. Then we went ahead, when we weren't able to get a settlement within the time of the statute of limitations, we decided to file our notice of intent to initiate litigation on September 2nd, which would, and that time, we were under the impression that that would toll the statute of limitation, granting us more time to negotiate a settlement, because during that time we were, passing documents to each other, trying to evaluate each other's claims. And we relied on this statute 627.70152 to toll the statute of limitations, which would allow us to go ahead and file suit again, granting us more time to negotiate. Nevertheless, SafePoint responded to the notice of intent to initiate litigation, relying upon the same statute that we did in their response. And when we filed that lawsuit thereafter, they moved to dismiss, stating that we filed our lawsuit outside the statute of limitations, citing Menendez. And with all candor to the court, at the time that we filed that lawsuit, I wasn't aware of the Menendez case. So that's my bad. But nevertheless, I know that since then we've had several different districts in the state of Florida come out with conflicting opinions as to how this 627.7015 statute is supposed to be applied, whether that's be, in the second DCA, which is where we're here today. They've decided that the statute does not apply retroactively. So I'm not going to waste time in this oral argument to go ahead and persuade you otherwise. We would like to state that we're resting on the briefs on that particular issue. Then we have the third and the fourth that are in conflict with the second, the fifth, the second, the sixth, and now as recently as the fifth. And I know this Florida Supreme Court is going to go ahead and take up that issue and decide which way all the courts need to follow as far as the statute goes. So I wanted to focus today on the second issue presented on this appeal, which is going to be whether or not the court improperly dismissed this action and not allowing the Murder Moreno and Mrs. Brown to proceed on their refiled case pursuant to the doctrine of equitable tolling of the statute of limitations. And the tolling of the equitable tolling of statute of limitations is not really a common thing that happens, but it's a legal principle that allows a court to prevent the statute of limitations from barring a claim under circumstances that would render the strict application of the law unjust. The tolling doctrine is used in the interest of justice to accommodate both a defendant's right not to be called to defend a stale claim. And really, there's four different factors that the courts look at in order to, it's two factors that the court needs to look at. Number one, the court needs to determine, did the plaintiff, was the plaintiff's excusable ignorance of the statute of limitations period? And they also need to look at, what kind of prejudice will the defendant suffer if this case were to proceed? And so, generally speaking, courts have applied the doctrine of equitable tolling of the statute of limitations in three circumstances. Was the plaintiff lulled or misled into inaction? Has the plaintiff in some extraordinary way been prevented from asserting his rights? Or has the plaintiff timely asserted his rights mistakenly in the wrong forum? And so we're stating, first of all, the defendant would not.
Does it matter that SafePoint was just kind of reacting to the Browns filing the pre-suit notice?
I'm sorry, I didn't understand.
Like who's reacting to who? Who's relying on who? The Browns filed it.
Correct. We filed the notice.
SafePoint was just responding to it. Just to can you if is there sort of like a invited reliance doctrine? I just made that up. But if by you being the one that precipitated the other party's action that you now claim you've relied on to sit on your rights?
So there is nothing explicitly in the record that I can show you definitively that shows that they invited us to go ahead and proceed under the statute. Okay. And I know that that's a big hurdle we have to proceed on. However, during these settlement negotiations, the parties were working to get as much time as possible before having to refile this lawsuit in order to try and resolve this issue of attorney's fees and costs that they're going after, and of course the refiling of this lawsuit, because we had litigated this case all the way up until the eve of trial already. All the evidence has been determined in this case. Jury instructions have been determined. The verdict form, everything is ready to go, with the exception of not actually having a trial. So the goal was, hey, look, we have this statute that is in play. This will give us more time to see if we can work out a negotiated settlement. And then if we can't, then we can.
Can I push back a little bit on that? I mean,
Absolutely.
you're proceeding under the assumption that file a new lawsuit, gets a new case number, potentially a new judge. We're just going to carry, hey, judge, good news. We're just going to carry everything over from that was done in prior lawsuit. You don't have to decide a thing. You seem to be assuming A, that the other side would agree to that, and B, the judge would go along with it. I mean, there's principles of comedy, of course, but the judge might say, hey, you know what? Some of the jury instructions I want to take another look at. Or it may come up, as is not uncommon, when a new lawsuit gets filed. There's been some water under the bridge, some rethinking of things. Maybe folks need to retake depositions. I mean, I'm not sure that you can dismiss much later, file a new lawsuit and say, oh, we're just going to pick up right where we left off in the new case. But that seems to be part and parcel of your argument on equitable tolling, which is like, hey, this really wouldn't be reinventing the wheel. So help me out with that.
So the idea is really the focus needs to be whether or not defendant has to defend against the stale claim. The evidence isn't going to change by the time it goes to a new case or a new trial, let's just say a new case. The evidence is still going to be the evidence. For example, there's not going to be any new evidence that says, oh, we have new damage and things like that. The testimony is already locked in. And if they want to change that testimony point, that's going to be easily impeachable based on the previous testimony that was given in the earlier case. So I don't,
maybe not change, but I mean, look, I used to do trial work. I mean, it is not uncommon for you get a trial date, it doesn't happen, and the trial date you thought you were ready, you had everything, and then in the interim, even staying in the same case number, your trial date gets set up, and maybe you find another expert, or maybe an existing expert takes a slightly different tack, and it changes changes things. I mean, I'm sorry if I'm not trying to bring that into the record, but I know how these things can happen and how they work. So help me out with that.
I understand the concern you're saying, and I think that goes more into strategy, legal strategy, but it doesn't necessarily change the evidence in the case. You know, and even when you take a deposition, right? You take a deposition of an expert, they're going to say one thing, and then at trial, of course, it's going to be what they previously said, if you know that they're prepared well enough, but maybe more elaborated and things that weren't necessarily covered. But the evidence is going to be what the evidence is going to be at the end of the day. I mean, that's just my position. And you know, when it comes to the prejudice, we stand firm in the fact that we don't believe the defendant would be prejudiced at all if we wanted to proceed forward with this lawsuit. All right. So with regard to, sure.
No, go ahead. No, go ahead. Thanks.
Oh, okay. Yeah. And so there's really two cases that I think that are on point for this discussion as far as equitable tolling. There's, of course, the McCull's case, which basically it's the McCull's versus the Department of Administration. That's Florida Supreme Court case. And there's the facts of that case, I think, kind of really go along with the facts of this case. And there's also the Oceana 3 Condo Association Inc. versus Westchester Surplus Lines Insurance Company case. And those, that's actually kind of follows exactly what we're going through here now. It's with Hurricane Irma and things like that. However, there's some nuances, I believe, as to why equitable tolling wasn't granted in the Oceana case and why it should be granted here. But let's talk about the Oceana case, okay? In that case, there was Hurricane Irma damages, and what happened was they filed the insurance claim, and then after the insurance company denied the claim, the attorney sat on that denial for approximately 9 months, almost up to towards the end of August, maybe if 2 weeks before the statute of limitations ran out. They did nothing as far as communication goes with the insurance company. They filed their notice of intent. And then after that notice of intent elapsed, and when the insurance company filed their response, in that response letter, they said, hey, look, we're standing on our decision to deny it. No, here's $500 to go ahead and get, to resolve this claim if the statute even applies. So they weren't even the defendant wasn't even operating under that statute per se, but they also requested an inspection. Inspections didn't take place, but even after that tolling of the statute of limitations under the new statute was extended, that the plaintiffs in Oceana still failed to file in time under this new statute tolling extension. And so that differs in our case because we were operating under this new statute. On top of that, if it wasn't obvious at the time, but it certainly is obvious now, there's definitely two ways to see how this statute should be applied, whether it be retroactive or not retroactively applied to policies existing before July 1st, 2021. And so I think that goes to show, and I'm not trying to suggest any kind of excusable neglect, but more importantly, and I'll fall on the sword, maybe attorney ineptitude, right? Which they discuss in the McCule's case. Not being able to, we made a mistake. We weren't aware of the Menendez case. However, at the time, we were operating under the new statute. We were reading the plain language of that statute. It was clear that all lawsuits that were
In
filed.
your defense, it was construing a different statute.
Yeah, I mean, I think that if it were any other statute and maybe all districts came to this opinion that Menendez applied, the statute does not apply retroactively, fine. But I mean, I'm coming before you guys today. I was the one who, quote unquote, made the mistake, right? But I think it's understandable, especially considering now the Florida Supreme Court has to decide how this thing needs to be interpreted. And when we're really looking at how we weigh this thing at the end of the day, whether or not to allow us to proceed under the equitable tolling doctrine, I mean, you got to look at the prejudice to the insurance company, and then you got to look at whether we just sat around and did nothing. We were trying to settle this thing. We were trying to act in good faith under this statute, which was essentially there to stop clogging up the court systems with all these lawsuits. And it's really tough because I was there, boots on the ground on this case, to not bring up things that are not necessarily part of this record. But this is a situation where we worked with the defendant. They knew we were going to be refiling this lawsuit as early as March 7th, 2022, when there was a discussion about whether or not the statute of limitations elapsed and whether we can refile.
Let's not get outside the record. I've no doubt that you all had extensive discussions. I think you all did a really good job.
You're at 5.5 minutes also.
I just want to say the part about the March 7th hearing thing, when we announced it, that is part of the record. Not necessarily the hearing transcript, but it's part of the motions that we had filed. Also, the letter responding to our 627-70152 notice, that was responded to. They clearly are moving under the same statute. And so with that said, we ask that you guys change your mind about the statute and apply it retroactively if you decide to. And then, of course, allow us, send this back to the trial court. Let us proceed on the merits. That's what we're asking for here today. So with that, I'll go ahead and reserve the rest of my time.
I'll save you 5 minutes.
Thanks.
Mr. Chinese, you next.
Yes. Good morning. Patrick Chidneys for the Appalese Safe Point Insurance Company. May it please the court. There are two arguments for reversal today, the one having to do with retroactivity. The court resolved that in the Buies decision. Because that wasn't extensively argued, and as counsel rested on the briefs, we'll also rest on the briefs. I'll just point out that the final request that this court change its mind is improper because of prior, as the court knows, prior panel decision is binding on this panel for the time being. So We don't believe there's any stated basis for the court to change its mind from Luis, or that procedurally that could occur.
Can he get this case in the pipeline? If the Supreme Court changes a ruling?
There are certainly procedural mechanisms that could be applied, but this particular panel is, as the courts aware, bound by the prior panel decision. So,
Well, I think what Judge Valenti is alluding to is, would there be any reason for us not to cite to our precedent to keep this, so that this case could travel, if you will, in the pipeline of this conflict issue that the Florida Supreme Court may resolve?
No, Your Honor.
You wouldn't have any objection to that, would you?
No, Your Honor. That it's the same legal issue as in that case. There is a second issue in this case that still requires, a consideration, but should still be affirmed. The only thing that we would ask is that, the court not delay this case further for various reasons. My client is an insurance company, keeps reserves, so I don't think there's a reason to stay the affirmance based on prior precedent with the citation necessary to seek review if necessary to get it in the pipeline. And to be candid, the appellant in Buis has done that. I believe the Supreme Court stayed their petition for review in the Supreme Court very recently. So we would ask the court to affirm based on Buis with whatever citation necessary to, as Judge Valenti said, get in line. I understand that. Don't argue with that. The primary argument today has to do with the equitable tolling angle. And before we get into, I want to address a couple of factual issues that I think are incorrect, but there are two large barriers that are sort of legal questions that weren't addressed in the primary argument. The first being the fact that this court does not recognize equitable tolling as a legal doctrine under the HCA Health Services decision. Judge Valenti, you were on the panel. That was an older case from, I think, 2004. In that decision, the court focused on what is the Maculez case that the counsel was arguing about. The key distinction in that case was it was an administrative proceeding. The administrative agency then sort of on its own said, yes, your appeal should be filed with us. We're going to set your hearing in Tampa shortly after the deadline to appeal to the Department of Administrative Hearings expired. So the Supreme Court said that was sufficiently misleading to invoke equitable tolling. This court came back to that and said that in the administrative context, there's nothing to say that doctrine couldn't apply. But in the context of a civil action, we have Section 95051, which is the legislature's statement of exactly what circumstances can operate to toll the statute of limitations. The court construed that the doctrine of equitable tolling cannot apply in light of that statutory language. So there's again, this goes to the fact that this three-judge panel is bound by prior precedent, that decision is binding today and eliminates the doctrine of equitable tolling entirely from the analysis. But there's a second legal reason, and I think you heard today the concession that this was counsel's unfamiliarity with the Maculez decision, or I'm sorry, Menendez, that the Menendez decision was applicable or that the statute would not apply retroactively. The short version is a mistake of law is not sufficient to invoke equitable tolling. And that actually is apparent in a case that the appellants relied on in the trial court called Lupola out of the first in 2015. They don't cite that on appeal, but there's a reason. In that case, the appellant argued that her husband had exercised control, prevented her from going to see a lawyer, couldn't understand that she had a legal claim. The court said that's not enough for equitable tolling because nobody prevented her from asserting the claim. In other words, equitable tolling may apply if somebody does something that either causes you to be unable to assert your claim or affirmatively misleads you in some way, or you're affirmatively lulled into, like, think of the agency scheduling their own hearing in a city and not telling the guy that the appeal deadline is run. But the fact that her claim existed in the first place was something to which equitable tolling could not apply. So the fact that the statute should not apply retroactively is not the kind of mistake. It's not the kind of lulled into an action to which equitable tolling would apply under the precedent they cited. But even if you get past, even if this court could ignore its prior precedent and the fact that the only identified mistake is one of law, there's 2 points of fact that I want to clarify. To Judge Atkinson's question about wasn't this just a response to their notice? It's more than that. Our response occurred 2 days after the statute of limitations expired. So how did you rely on our response to make the decision not to file within the statute of limitations? It's temporally impossible. The second question had to do with, there was some discussion with counsel about settlement negotiations that were ongoing. There's nothing in the record about these settlement negotiations, at least, their content, what they said. The important point is that what is in the record, and it's in their rehearing at record 165, is that these discussions concerned our proofs of our attorney's fees. That's the only thing factually in the record, is that they were trying to negotiate the fees that we're entitled to because their first lawsuit was dismissed, partly for fraud. And there are findings of fraud in that case. And that's going to go into the prejudice angle. But The settlement discussions were not about settling this claim. Maybe they involved this claim.
Are you going outside the record? I thought you said that was not in the record.
No, the fact that the only thing in the record is that they were discussing attorney's fees. That's at record 165. They said they were discussing the claim, but if you think about this, the first case was dismissed. It's in the record that we were entitled to fees in the first case. Their discussions with us in terms of settling had to do with resolving our fees in that first case. The fees in the first case exist independently. Our fee entitlement in that first case exists independently of the merits.
What's that got to do with this case?
It has nothing to do with this case. That's right. That's the point.
Then don't talk about it if you don't mind.
Sure. So the fees. Oh, I apologize, Your Honor. My point is only that the negotiating fees in that first case is distinct from negotiating this claim. That issue would exist regardless of this case. So to say
we got you.
Okay. The final point, the discussion about prejudice, the discussion that Judge Lucas brought up about whether the facts in that case would apply here, I would simply submit that that case was resolved for very different reasons. It was dismissed by the plaintiffs. We would not concede that the facts in that case would apply here. Our defenses would be different. Times change. As the court knows, memories fade. The state of the property changes. It's not as simple as just plugging that case into this case and saying it's resolved. And I think that brings it brings the argument to the Oceania 3 case, which is, eerily similar to the facts here. It's virtually the same factual situation. The plaintiffs there delayed until shortly before the statute of limitations and then submitted a notice of intent and then claimed that the insurer's response to the notice of intent was sufficient to invoke equitable doctrines that would have told the limitations. The federal district court applying equitable tolling, because other district courts of appeal admittedly have applied equitable tolling in the civil action context, but applying equitable tolling, what the court said was the circumstances outlined by Oceania amounting to a last-minute choice between complying with 627-70152 in the hope that its tolling provision would apply and timely found suit within the statute of limitations are not the sort to which equitable tolling has been applied. We would, in short, it's a decision that occurred because they waited until the last minute. If they made that decision 2 weeks earlier, none of us would be here. As far as I'm aware, there's no authority cited that type of mistake can invoke the doctrine of equitable tolling, nor has this court applied equitable tolling in the civil context. Given that was the extent of the argument, and unless the court has other questions for me, we would ask that the court affirm.
All right, let's move back to Mr. Barnard. You asked for 5 minutes. I think I said I'll give you 5 minutes.
Okay. Let's see. I just wanted to go ahead and, briefly touch on the fact of the Oceania case. It's a little bit more nuanced than that, in my opinion. When it came to what happened in that case, this is a situation where after the claim was filed and thusly denied, then denied, the attorneys did nothing with the insurance company. They were not in any kind of communication. There was no notice to the insurance company that a notice of intent would be filed or anything like that. That is completely different from what we had in our case. They knew as early as March 7th, 2022, that we intended to file our lawsuit again. Additionally, when they responded in Oceania, there was no response, which indicated that they were relying upon the same statute, which was the 627.7105, and that the response was in accordance with that statute. They just said, look, if it applies, then here's our response in relation to that. I think there's a difference in that case. I think that we've shown that this claim isn't going away. There wasn't going to be a possibility that we would just walk away from this claim. We had every intention to file a lawsuit again. That I think is the distinction from the Oceania case. Additionally, and it just escaped my mind, I just want to make sure that let me look at my notes real quick. There was a conversation about, the settlement discussions and things like that, and that it was only about, that is just, we're talking about the claim. We're talking about everything related to this. In order to get a release done, we got to resolve everything. So that's the only point I wanted to make. And so with that said, we ask that the court look at this case. It's completely unique compared to the other cases. In Oceania, there was no initial lawsuit filed. This wasn't a delay in filing the first lawsuit. This is a situation where the refiled lawsuit didn't happen because the negotiation conversations were happening and we were relying upon the wrong statute, or the right statute, but not to be applied retroactively, depending on which district you're in.
At
So-
that time, the Menendez in this district had not been applied to this statute. Or am I correct? Am I incorrect? But Buis had not been issued at that time.
There has not been any opinions by this district about Menendez. The only thing that defendant might cite to, because I want to be candid with you guys, is there was per curiam of firms related to AOB cases, if I'm not mistaken. And that was it, citing to Menendez as far as the notice requirement goes. And look,
Prior to the Buis opinion.
Prior to the Buis opinion, and I don't know whether or not if those per curiam affirmed decisions, which I believe are not really binding, are not, and I'm not saying binding, but
They're not under Florida Supreme Court precedent. They're not.
right. So we didn't have any guidance necessarily on this issue outside of Menendez.
What about the other districts? I mean, at this juncture, there were other districts that went in a different direction, that they had not been issued either.
The first opinion that came out was Cole, and that came out in May of 2023. We filed our lawsuit in September 22nd, 2022.
You got about 2 minutes left if you need more time.
Are there any other questions? Because I think I'm pretty much done with my arguments, Your Honor.
No? All right. Well, thank you, gentlemen. Interesting case. We'll move on to the last case on this particular calendar. That's going to be Wesley and Davis. So you fellows can go home. Have a nice day.
Thank you, Your
Thank you,
Honor. Good to see you, Patrick. Take care.
You as well.
All right. Both sides are present. You both ready?
Yes, Your Honor.
All right. Please proceed, Mr. Wardell.
Actually, I'm the appellant.
The other way. Okay. Well,
Yeah.
I looked at the.
Thank you. That's no problem. I'm Brandon Wesley.
Yes.
I'm from the Florida appellate firm. I represent Rudolph Wesley and the Executive Mortgage and Investment, Inc. I'd like to reserve 5 minutes for rebuttal.
All right. You got it.
May it please the court. This case involves a non-arm's length transaction whereby Curtis Davis, the vice president of executive, deeded over a valuable piece of property to his college friend. Mr. Decollette, which is his friend, had a second mortgage on the property. And yes, Mr. Decollette paid off the first mortgage on the property when it was going into foreclosure. But Curtis Davis, who subsequently went to prison and was defaulted in this case, had no authority to offer a deed in lieu to his college buddy.
Isn't that a factual issue?
Sorry?
Isn't that a factual issue?
Did he have authority?
Whether or not there was sufficient authority, or whether an agent bears authority to act on behalf of a corporation?
It would be a factual issue, Your Honor. However, there's no evidence in this case at all.
Wasn't there a request for admissions that he was the vice president?
Well, Your Honor, being a vice president doesn't automatically give you authority to deed property over. That's the statutes that we're going to talk about. There's 3 of them. And the first statute, 692.01.
I understand the statute, to pick up where Judge Little left off. I understand that statute, when the statute that mentions that particular officer includes additional requirements. But under 689.01, to ask Judge Lucas's question a different way, how is a court, let's say that we weren't operating at all under 692.01 or 692.102. Let's say opposing counsel never even mentioned them and just said, we're operating under 689.01. How does a court determine whether a lawfully authorized agent conveyed the property? How do they do that? How do you establish that?
Evidence, Your Honor. They have to present evidence at the hearing, and there was no evidence presented on their side. Like I said, Mr. Davis was defaulted, and all of the evidence.
So you would concede that even though one of the other statutes mentions the vice president and includes additional requirements, that doesn't foreclose the possibility that under 689.01 on isolation, a vice president could be a legally authorized agent of a corporation, right?
If he had a corporate resolution or he had authority from the president, but in this case, the evidence was crystal clear that he didn't have that authority.
What about the evidence that from the president that said, well, he was running things at the time?
That doesn't give him authority to transfer property, Your Honor. He has to have authority. If you look at the case that the George versus Miller Bay paralegal, that case from this court, Judge Valenti's opinion, the same situation occurred there. There was no evidence to show that the person had authority. It was all one-sided, and that's exactly what happened in this case, Your Honor.
Well, help me out too. Like, this was basically a deed in lieu of foreclosure, right?
That's correct.
Were there substantive defenses to I'm saying this wrong, I'm sure, DeCloet's foreclosure? I mean, what was the corporation going to defend on when its president was basically out of the picture? Did it have any other, I mean, is there any evidence that it had any other assets, that it had any defenses to this? I mean, what?
Well, there was not clear evidence he was completely out of the picture, Your Honor. He did say that Mr. Davis was running things, but at the same time, what you're talking about, he actually, Mr. DeCloet, he paid off the mortgage that was in foreclosure. So then he assumed that claim. I guess he could have brought that claim, but it never happened because almost immediately this deed in lieu of was given. But you know, the property had value, and obviously there's deed in lieu. Deed in lieu is to avoid having, you know, generally, I mean, just generally speaking, it's avoid having an upside down property, you know, go through the process. But we wouldn't be here if that was the situation. Anyway,
not always.
So Your Honor, let's talk about those requirements and the authorization that is needed if you're going to rely on 689.01. He did have the presence of two witnesses, and he did sign it, but he needed authorization. And the evidence in this case, not only is the evidence my client's testimony that he clearly did not have authority to do this, but there's also evidence in this case that every other deal that Mr. DeCloet did with Executive, and they had done several over the years, every other deal and every other instrument that needed to be signed was not only signed by Mr. Davis, but was also signed by Mr. West.
Right. And Mr. Reesley, I appreciate you bringing all this up, and I'm glad we're getting down to brass tacks of your argument, which is basically the trial court got it wrong on the facts. But this comes to us after a trial, right? So help me out with that. You know, you're saying that basically that there was the trial court could not have entered this judgment based upon the facts before it. You've done a lot of appeals. You know that's a high standard. So
absolutely,
help me with that high standard.
I want you to look at the fact that this trial occurred in November of 2022, and this judgment didn't come out until July of 2023. So we're talking there's a 7-month period in there where we don't know what's going on. The parties were submitting findings of fact, conclusions of law, and there's, you know, we don't know what happened at that point. But what we do know is at trial, this particular judge honed in on George versus Miller Bay and talked about it and specifically pointed out the exact same argument that we're making and used that argument to deny a directed verdict.
You're saying the elapsation of time might have contributed to the trial court's changed thinking on whether George Anderson controlled, but
or
the elapse, how can we, but it's still a fact issue, right?
And then the greater part of the argument is, Your Honor, he applied Prezesio versus Cameron out of the fourth that predated our George versus Miller Bay decision by 31 years, and it's the wrong district. He's applying that case, and then if you look at that case and you look at we did a request
applying a different statute, you're saying too, right?
He applied a different statute. He was applying 92. He wasn't even applying.
Well, I'm saying that case cites that relies on a different statute. I can't pronounce it either, but anyway.
Prezioso, Prezioso focused on 689.01. In Prezioso, like I said, 4th DCA, 31 years before Miller Bay, the George versus Miller Bay, and Judge Valenti's opinion in that case. In Prezioso, the court talked about, sort of in generic terms, that the vice president would have authority, president, vice president, CEO would have authority to do this with 2 signatures. But what you didn't hear, and what was not included in the opinion, was that they actually had a seal on the deed that they're talking about. And we found that, and we asked the court to take judicial notice of that public record. There was a seal, a corporate seal on that deed. So it really, unfortunately, I think the court got it right, maybe in Prezioso, but only from the standpoint that there is actually a corporate seal on that deed. Otherwise, they're dicta, if you will, because I don't even think they relied on that particular issue to make that ruling. I think it was more like dicta. I think that, the court should look past it as being incorrect. So, it's clear the court was aware of this court's decision in George Anderson training. 7 months passed, memories faded. I don't know what happened. Nobody knows. You can only speculate. But I think it's obvious that the court recognized what we're arguing now, and what we're arguing now is the statutory law requires a vice president to either have a seal or have some authority, corporate resolution or something. If you look at
The problem with
Is
that
that
argument.
a correct statement? Sorry, Judge Lucas, go ahead.
Oh, I was just going to ask, just real quick, the problem with at least the first part of that argument is that the statute that they're traveling under expressly states no seal shall be necessary. I mean, again, I'm talking about 689.01. No seal shall be necessary to give validity to any instrument executed in conformity with this section. So how can you read back in? Look, they can either get an official authorization or they can get a seal when the statute says they don't need a seal.
Well, again, Your Honor, they have to have authority.
Right.
It'd be corporate resolution, or the president could have done it like he did with these other instruments with Mr. Decolette's animal genetics company. They have to have some authority, and he did not have authority in this case. The evidence is clear he did not have authority. So you're asking the court why? You're asking me why why can't he do it under 689.01? You can imagine if a corporation, and lots of corporations have multiple vice presidents, if they can just go out and sign over deeds and those deeds stand, it's going to put this is what they're trying to avoid here. They have to have some corporate resolution, some authority given to them to make this deed. And if you look at 692.02, which we cited in our brief as well, that one talks about how if a vice president has a seal on the deed, it should be considered valid. Now, why would they need that? They wouldn't need that at all if they could just willy-nilly sign over deeds because they're a vice president. I mean, the president.
Not because he's the vice president, because he's an authorized agent.
You would not even need these other statutes, Your Honor. You wouldn't need any of this because then you wouldn't need a corporate seal.
Well, doesn't 689.01 say you don't need those other statutes? It says you can go under this statute or the other statutes.
That's correct. But you have to have authority. And you're assuming he has authority to deed property when there's nothing in the record to suggest.
Well, let me ask you this. You keep saying there's nothing in the record, and isn't that you've distinguished Prezalewski, or I forget the name, but but isn't George Anderson distinguishable in that there was the evidence against authorization was unrebutted, whereas here, yes, Mr. Wesley provided some evidence of lack of authority, but it was not unrebutted.
It was
also evidence of authority. Even if you say, sort of eliminate the course of dealings type of argument about the past conveyances, because as you said, they included the president on them up until this one conveyance. But isn't there other evidence? I'm sure Mr. Wardell is going to talk about it. You might want to talk about what evidence he's going to say rebutts Mr. Wesley's evidence of lack of authority.
So let me just set the record straight here. There was an issue in this case early on. Was he even a vice president? Was he just a CFO? And of course, none of these statutes talk about CFOs. So the issue that they honed in on initially was he's not even a vice president. And so there was a lot of back and forth on, is he a vice president or not? That's where all this information came in. It wasn't whether he had authority. It was whether he's a vice president. And we're conceding that he was a vice president. But we're saying just because you're a vice president doesn't mean you have authority. You have to have some kind of authority. And this case was devoid of that. They could have gone and got a deposition from the man in prison. They could have presented evidence that showed that. There's nothing. They had one witness, Mr. Decollette, and he came in and he said, well, I assumed he had authority. That's not evidence. You can't
Didn't Davis
assume.
file a corporate amendment?
Sorry?
Did Mr. Davis file a corporate amendment making himself a vice president?
Yes, he filed his own corporate amendment making himself a vice president.
And Wesley didn't know about that, but the judge found something in his final judgment saying, so what? It still was valid. Is that correct?
Yes, because I guess anybody in the corporation can fill out that form and say who's who.
Well, he compared signatures.
Sure, but yeah, we're not disputing that he's a vice president.
I mean, you did a motion for
No.
rehearing and it was denied, pretty basic. Was there a hearing on the motion for rehearing or was it denied without a hearing?
It was denied without a hearing, Your Honor.
So you have no way to know what the judge was thinking because the denial doesn't tell us a whole lot.
Right.
Okay, gotcha.
Yeah, Your Honor. So my argument is, if this court is going to rule in their favor, they have to take the evidence that's been presented, the limited evidence that's been presented, including my client's testimony, no authority, all of these documents that have been signed by both Mr. Davis and Mr. Wesley that are within the Decollette collection, and then turn around and say he had authority just because he's a vice president. That's not what the statute says. You can't, just because you're a vice president doesn't mean you have authority. And there wouldn't be any need for these other statutes if you had that kind of a case. So anyway, so they're also going to argue that that it's not that Mr. Decollette's statement that he thought he had authority is sufficient, and that doesn't work with the statute. That's not a proper analysis.
You're down to your 5 minutes. Did you want to save that for rebuttal?
I'll just finish it real quick here. It's
All
not
right.
a proper analysis on the statutes, and it must be noted that all of these other documents said otherwise. Okay, I'll reserve the rest of my time.
I'll give you the 5 minutes.
Thank you.
All right. Happily. Mr. Wardell.
Thank you, judges, and good morning. I'm James Wardell on behalf, and I don't know if I'm saying this right either, but I've always said DeCloet, and I'll refer to him as Mr. DeCloet. Judge, in this case, what the court did was it took a plain and just reading of a statute and led to a plain and just result in this case.
You said the court did that. How do you know the court did it the way you're saying it?
Well, that's what the court said that it did in its actual order. The court did make findings and the court determined based on the evidence. And it was interesting because the court used mostly Mr. Wesley's testimony and he put that in the order. And then he also referenced the admission that, they originally proceeded under this case under some theory that he wasn't a vice president, but then the facts were overwhelming and they had to admit that he was a vice president. And then they tried to kind of change their argument. So the court went through all of that in its factual findings, and it ultimately made the findings at number 12 and number 13 of its order that the court finds that Mr. Wesley appointed Mr. Davis to serve as vice president of executive in 2002. And the court did ask earlier, Judge Valenti, you did, about whether the vice president presented some stuff himself or filed some documents himself. Well, the court found that it was Mr. Wesley that signed that amendment, and he made that factual finding in his order. So he determined that Mr. Wesley's testimony, without saying it, was disingenuous, but he said it didn't matter because they ended up admitting it later, that he was in fact the vice president. The second finding of fact was that the court finds that Mr. Davis acted as vice president of executive from his appointment in 2002 through the execution of the subject deed in 2014 and that he did so at all times with the knowledge and consent of Mr. Wesley. And that raises some points, some other factual points that some of the other justices brought up, was that Mr. Wesley was nowhere to be found during the time frame. This was signed in 2014, and he didn't even raise an objection to it till 4 years later, because he was not active in the business at all. He left it all to Mr. Davis to wind down the business. And when I say it was a just result, this is not something where Mr. Vesley's suggesting that this is his college buddy or something. He had Mr. DeCloet paid. He made a loan that is not disputed, that was recorded, was a second mortgage, and then that second mortgage wasn't paid, and then the first mortgage wasn't paid. So Mr. DeCloet, in order to protect his position, had to pay off the first mortgage. So it's just in the sense that he paid for all of this, and none of that's in dispute in this case at all. So when we say the court did a very good job of making factual applications and applied the statute, which is 689.01, it specifically says you don't need a seal. And the court made factual determinations that Mr. Davis had the authority as vice president to convey this property. If you do look at it in conjunction with some of the other statutes, 692.01 and 02, which you don't have to, but if you do, I think it helps our position even more, because under those facts, it basically sets out that a vice president does have the authority to do this. And it looks from the perspective of the person that was the beneficiary in this case, which is also, that's Mr. DeCloet. And he had the ability from his perspective to be able to rely.
Are you saying the court could make that finding without copy of a corporate resolution, or the testimony that a corporate resolution occurred to give him that authority?
Well, Judge, I think he could. I don't know that there's any requirement that a corporate resolution would have had that, but he cites the Prezioso decision. And again, I'm probably saying that wrong too, but I know everybody, since we all got it wrong, I feel better about it. In the bottom of that case, it says the court noted that the practical purposes of section 692.01 is to allow third parties who transact business with corporations in an honest fashion to have confidence that the transactions are valid. We agree, as this section indicates, the officers of a corporation are vested with apparent authority to conduct the corporation's business. Absent fraud on her part, a party doing business with a corporation is permitted to rely on the officer's status within the corporation as sufficient power to bind the corporation in the execution of mortgage instruments, which is exactly what we have here. Now, the Miller Bay decision, Your Honor, which I know, Judge Valenti, you authored, it's completely factually different. I mean, to have that was basically a woman committing fraud at like 3 different levels on 3 different deeds for something that she was taking the money for, that's selling a property that she didn't own. So under those facts, completely distinguishable from this particular case, where a just application of a plain reading of the statute results in a just decision. In that case, based on those facts, the lady was never even the president. So, and nothing was contested. She didn't show up or respond or anything like that. So it wasn't a situation where a court had a trial where the judge made factual determinations and actually used the testimony of Mr. Wesley to come to the conclusion that Mr. Davis had authority and there was no fraud anywhere, and that Mr. DeCloet had the ability to rely on him as a vice president.
Wasn't there also evidence at trial that that Mr. Wesley was aware and on board with the underlying loan itself of DeCloet and taking over the first mortgage? That he knew all about that and had a discussion with Mr. DeCloet?
Well, there was, I believe there was some testimony to that effect, but he was no longer involved in it. It acknowledged that the first mortgage wasn't paid and a foreclosure action had been filed, and that Mr.
What I'm saying is that he did know about the underlying transaction itself I mean, he admitted it in his testimony.
He did, yes, Your Honor. So
And that Mr. Davis was part of this, this deal. Which it sounds like it's kind of like a deal-centric kind of business, right? Because Davis gets brought on board as a loan, I guess like a loan officer. He's maybe got a stake in like an ownership interest in the company. And it's kind of like they just do these various deals together. So at least until it's unrebutted that at least up until the deed in lieu of foreclosure, which is what I'm calling it for shorthand, he knew about the DeCloet taking over the unpaid first mortgage and his subsequent interest in the West Shore property.
I mean, I know that he was on all the documents in the original foreclosure action that was filed that Mr. DeCloet had to settle by paying off the first mortgage. So I think it's definitely can be inferred from the record that he had knowledge of that. If I don't specifically remember if he admitted that, but he probably did. But there's no question he knew about it. And all of this from the timing was, Mr. Wesley left all the business because everything was upside down at the time after the 2008 property crash when Mr. Davis was the only one managing, kind of winding down this business at the time. So I think that all of that goes to kind of the factual findings of why the application that Judge Nash did such a detailed, wrote an order and put these factual findings in and relied on that. And what Mr. Vesley said about, we don't know why he changed his mind and maybe you forgot. Well, that's not the case at all. I mean, that was a motion for summary judgment and he was just, we had a trial after that. And he didn't issue the order right away after the trial, but the summary judgment when he was, allowed them to go forward to trial, that's when he basically cited to the Miller Bay case and asked some questions about it. But after hearing all the facts of this case, he decided otherwise and he wrote all of that in an order. So I don't think that's any indication that perhaps he forgot or got confused somehow. I think he did exactly what was right based on the facts and the conclusions of law. And he relied on 689.01, which I think is absolutely correct. There's no requirement anywhere that they're doing such a narrow reading trying to say that a person with authority has to be some authority that's granted in writing. It doesn't say that anywhere. And if you certainly look at it from Mr. DeCloet's perspective, there was no reason not to believe that the deed in lieu of foreclosure for the property he already paid for by paying off both of the mortgages wasn't valid, and Mr. Davis had the authority to do it because he was the only one running the company at the time, which is a factual finding by the judge, based on the testimony of Mr. Wesley. So,
That it?
Your Honor, that is it. Thank you.
Thank you very much.
Oh, I'm sorry, Judge, if I can take that back. I did file a notice of supplemental authority for the DGG Corp versus the estate of Capone, and that is at 983 Southern 2nd, 1232. And that case is very factually similar to this particular case. And in that case, it says the corporate seal was not affixed to the deed, but it was executed in the presence of two witnesses and a notary public, which is what we have in this particular case. And then after the corporate resolution was reinstated, the decedent and the wife conveyed the property to the decedent and the guarantees. The appellate court noted that under 689.01 and 692.01, if the person executing a deed not under seal was not the corporation's president, vice president, or chief executive officer, an authorizing resolution from the board of directors had to be obtained. So basically, in that case, they overturned the decision because the conveyance of that particular interest was done by a secretary as opposed to a president, vice president, or chief executive officer. So it basically was saying what happened in this case was the right way to do it, and that a vice president does have the authority to convey a deed, and that's consistent, of course, with Prezioso, which is the intent allowing people to rely on that. Thank you, Judge.
All right, thank you. Mr. Vesely, you asked for 5 minutes rebuttal, and I saved you 5 minutes.
Thank you, Your Honor. You know, what they're advocating here is that any vice president, under any circumstance, if he can get 2 witnesses and a notary, can deed away property without any problem.
Can
And-
you explain away the case he just cited in his supplemental authority?
Yes, I can, Your Honor, because they just got it wrong. It's a 5th DCA case. There was dicta. It says similarly, if a deed is executed, and they're giving like an example, and they got it wrong. This is not what 689.01 says. It says you have to have authority, and the authority is important because any vice president and any CEO and any president could just, well, the president, I always.
Well, here's my question. The facts of this case were the vice president made himself vice president. There's no objection. He ran the company. For how long did he run it? And he had to do day-to-day activities. That's basically the testimony, true or false?
Absolutely. Vice presidents do day-to-day activities all the time, Judge, but they don't
But
deed
giving
away
away the
property that
farm is
belongs to
another
the
story.
corporation. This
I
is a piece of
understand your argument.
property that had value. And the fact of the matter is, you know, if this had gone through on a foreclosure, it would have gone to sale, and then our argument would be that there's going to be some money at the other end of it for the corporation because it's valued.
Yeah. No, I understand your argument.
So
It's a good argument.
that's the point. That's the point we're trying to make. Prezioso 692.01, it requires a seal. Prezioso is relying on 692.01, and it talks about how the vice president has all this authority if he has a seal. He has to have the corporate seal. You know, obviously, if you give Mr. Davis the corporate seal, he has the authority to do it. But if he doesn't have the corporate seal, you got to read your own words in George versus Miller Bay, because it's right on point. And it is not. They didn't talk about the fraud. They talked about 689. They talked about 689.01, and it talks about how there was no evidence to show that this person had authority, and without some evidence to show he had authority, then he couldn't do it. He couldn't transfer it away. He needed authority. So, Your Honors, you know, if this were a similar case and this property was worth, you know, $10 million and the mortgage was only $100 million, and this person signed it away, you could see the injustice there. And I'm not saying that's the case. We don't have those facts, but I'm saying you can see why this is important. You can see why the statutes require a vice president to actually have authority to be signing away deeds from property. And, you know, I get it. Mr. Decollette put a lot of money into this because he had the first mortgage, the second mortgage. I get it. He's entitled to be paid, but he's not entitled to get a windfall. And that's where we're at. I know it's not fraud. We're not saying it's fraud. I'm saying that this person didn't have authority to do what he did. Let's undo it. Let's let Mr. Decollette, you know, either foreclose or get reimbursed by getting a second, you know, a third party financing or something. But, you know, this is not.
What of the fact, I don't know that the trial court made much of this, but what of the fact that there was some testimony that he not only was vice president, but a 15% owner of the company? I mean, isn't that also a fact that could imply that he had some kind of agency?
Well, 15% is less than 50%. So, I mean, obviously, but
work with me on the terms of my question.
15%, you know.
It isn't 50,
what if you're vice
but he's an
president,
owner.
What if you're vice president at Amazon and you have 1% of the company and you did sign away the deed to their you know, their corporate headquarters? Is that going to be enforceable?
I might be liable in fraud for a whole bunch of money for having done so.
You got about a minute to.
They didn't have authority.
Call my corporate D&O carrier. You know, I mean,
I guess, Your Honors, this case boils down to a very simple proposition. Does a vice president, absent some kind of written authority or some kind of clear indication from the president, get to deed away property? And these statutes talk to that. 6 at 92.01 specifically says, oh, he can do that, and it's going to be enforceable as long as it's got a seal on it. 692.02 says that. 692.01 says, hey, president, vice president, CEO can transfer as long as they have a seal. So, and then 89.01 says, well, if they have authority and they get the two witnesses and they get the notary, then they can do it as well.
Mr. Vesely, you did a
Support.
fine job, but you're out of time now.
Thank you, Your Honors.
I
appreciate
want
it
to thank
very
you
much.
both for a great presentation, and we'll be adjourned. Thank you very much.
Appreciate it.
Thank you, Judge. Yeah, I was worried, of course, having Judge Valenti's terrible. That's your opinion on the case of that. So, I don't know. Yeah, I think we should wait. Let's fucking go. Huh? You nailed that. Did you watch it? Yeah. What do you think? Did you want? Yeah. So, well, let me look at it. But I like the other two.
Yeah, that supplemental case was big, but he's arguing like public policy arguments, which is always, you should win on those.
Well, I tried to frame it like the judge made these factual findings, and it's because of the fact of right. You know, you